Do you know the exceptions to needing a warrant? Search incident to lawful arrest. The police may search a person, any area surrounding them, and any area within their wingspan, or their grab area as we like to call it. This is done in the name of police safety. However, if they find illegal items other than weapons, they may seize them. California v. Chimmel, 1969, Supreme Court of the United States, consent. This is a big one. This occurs when you effectively give a waiver to the police. This is never recommended. Only bad things can happen. You never benefit from doing this. Consent can be given without a lot of people even knowing it. So it really isn't hard for the police to even get. For the consent to be nullified, the facts must demonstrate that the police used duress or coercion to obtain consent. Schneckenloth v. Bustamante, 1973, 90% of warrantless searches are based on consent. Another consideration is that police can accept consent from someone that they reasonably believe have access to the property. For example, people who live with their parents. Their parents may be allowed to give consent if the police believe that they have reasonable access to their kid's room. Plain view exception. This is exactly what it sounds like. If officers see something in plain sight, they may use it as grounds for the search. For example, if a police officer is walking on a sidewalk near an open garage and sees a pile of white powder next to scales and plastic baggies, that will give them probable cause for a warrantless search. However, if that same officer comes up to that garage and all of those items are inside a duffel bag, the officer will not see it in plain view, and thus will not have the grounds for a warrantless search. There are special requirements for this exception. Police must be in the area legally. They are not allowed to walk up to a window in a residential neighborhood to find an item in plain sight if they would have needed a warrant otherwise. Lastly, the incriminating nature of the evidence must be apparent. Stop and frisk is allowed when there is reasonable suspicion. There must be reasonable suspicion that someone has committed a criminal act or is in the process of preparing to do so. An officer can stop and briefly detain an individual to determine whether criminal activity is underway. During the detention, the officer may pat down the detainee for weapons. That comes from a famous case, Terry versus Ohio, that went to the Supreme Court of the United States in 1968. This only allows officers to pat down somebody. They are not allowed to reach in their pockets unless they feel that there are weapons from the outside. A big deal in New York City just a couple of years ago when the mayor allowed officers to set up stop and frisk areas. Those areas were set up almost like DUI stops. Another exception is the automobile exception. Police do not need to get a warrant to search a vehicle if they have probable cause to believe that there is evidence of a crime, contraband, or fruits of a crime inside a vehicle. This comes from Carroll versus the United States in 1925. It wasn't practical to get a warrant if probable cause exists. This doesn't include being pulled over for rolling a stop sign, however, but it can be satisfied by an anonymous tip. Even though it's called the automobile exception, this also includes boats, not just automobiles. Another exception to the warrantless search requirement is exigent circumstances. The classic example is a police officer walking by a building and hearing screams from inside. The officer is then allowed to go inside and investigate without a warrant, only for the purpose that created the exigent circumstance. In turn, this brings up a lot of cases having to do with one of the previous exceptions, plain view. This also comes into play a lot if the evidence might be destroyed if the officer doesn't get inside to search. The classic example are drugs being flushed down the toilet. That comes from Kentucky versus King, 2011. The rule is, if a criminal is fleeing and enters a private home that the police would otherwise need a warrant to enter, the police in hot pursuit may also enter the home to effectuate a lawful arrest. They are not allowed to leave and come back at a later time or day, however. It must be in hot pursuit.